To Constitution headquarters. Let me give you guys a little bit. Let me step back. I got to carry my mic and my tripod at the same time. So let me kind of give you guys a little bit of a brief understanding of what I've done over the past year. So as you guys know, or some of you may know, I was wrongfully put in a dungeon last year for 4 months. My conviction was overturned on appeal. And when I was in that dungeon, what I did was I took the time to read a bunch of books on the history of the Constitution, the Bill of Rights, specific Supreme Court justices, presidents, things like that. So I spent a long time studying. For the past year, I have been building this wall behind me here. And here at Constitution headquarters, this wall represents, from the very beginning, the 7 articles of the Constitution. And then the case law across the wall goes all the way down to 2025 when Trump was elected president. So now, through my studies, what I have been able to learn is that the Supreme Court has worked against us since the very beginning. Now, if you take a look at the title of this video, give me a 5x5 if you guys can hear me okay. I'm not sure if my mic is working or not. I hope it is. I got to carry my mic with my tripod here, but I'm going to do the best I can to teach you guys the case law and how America fundamentally lost the Fourth Amendment. This is the wall that I've been building for the past year. You got a map over there where I'm going to lay out the circuit courts for you. I'm going to lay out the district courts. I'm going to lay out a lot of things for you today. And then here you're going to see that I have a few of the amendments printed out big on the wall. The First Amendment, RAPPS, Religion, Assembly, Petition, Press, Speech. And then here as well, I hope these cases are not backwards for you. I wonder if they are. I wonder if there's a way that I can fix it. But let me know. Can you guys read the cases? I can't see any comments yet. So let me know if you guys can read the cases and they're not backwards. Hopefully they're not backwards. What's going on, Chris Beaumont? So are the letters on the screen backward for you, Chris? I'm not sure if they are or not. Hopefully they're not, because it'll really, I think that they are backwards. I hope that they're not. You can hear me okay? Okay, so this case breakdown that I'm going to teach you today from Constitution headquarters, they're backwards. That's a bummer. That's a real bummer. That's why I have never been able to do this live. I imagine, you know what I could do? You know what I could do? I won't be able to see any comments. So let me see this. Let me go like this. Let me go like this. There we go. Okay. So I'm not going to be able to see. It's a bummer. This is the reason why I haven't been able to do this live, because I can't see exactly what you guys can see. So I imagine that I'm just not having a camera. I'm just going to show you guys the case law, and we'll take it from there, hopefully. There we go. Okay, push it down a little bit more. Okay, is that a little bit better? Now, unfortunately, you're not going to be able to see me, and I'm going to have to get something here. But we're going to dive right into this. And so our country was fundamentally ruined. I mean, I really wish that I could be on camera with you guys and show you guys exactly how this works. But unfortunately, I can't be on camera because I can't have the camera on. Unfortunately, I cannot be on camera at the same time because it kicks out the cases backwards, which is, I may just stop this live stream and start another one. It's super, super duper frustrating. Okay. Do me a favor, everybody, hit the like button. You know what? I'm pretty frustrated with this already because I can't be on camera and teach you guys case law at the same time. Maybe I could. I just can't see what you guys can see if I go in front of the camera. It's such a bummer that I can't be on camera and teach you guys at the same time, but oh, it's frustrating because YouTube doesn't allow you to mirror the, yeah, it's not gonna, Such a bummer. Let me see if I go like this. I could just do it like this and then. You can do it. Okay, let me see what you guys can see. 1 second. Okay, there we go. Now I can do it at the same time. So you're gonna have to forgive me because I'm gonna have to reference my camera as I look at my camera here. I'm gonna teach you guys how America was fundamentally ruined based 100% on prohibition. So this is gonna blow you away. I actually did this last night in my studio. So unfortunately, I'm gonna have to hold my phone so that I can see you guys at the same time that I'm teaching. And I'm going to teach you some stuff today. This is going to absolutely blow you out of the water. If you're unfamiliar with case law and you don't know how our country got screwed, let me explain it to you in no uncertain terms. Our country got screwed because of prohibition. So as you know, as you may or may not know, let me see the 18th Amendment. Are we on camera here at the 18th Amendment? Let me slide this over a little bit. Okay, cool. So the 18th Amendment was originally the Volstead Act. The Volstead Act was passed in 1919. The Volstead Act made it illegal to have alcohol in the United States. Now, the 18th Amendment is going to be ratified. This one right here. Let's see what you guys can see. It's a little bit of a delay on my phone. But this 18th Amendment, what it did is it criminalized alcohol in the United States. And this was a long process. This was started with the Temperance Society going back to 1820, and every single president, there you go. Every single president here, every single elitist that you see on the wall, they were all a part of the Temperance Society. They all wanted to criminalize alcohol. All of them did. It was universal, even though a lot of the presidents continued to drink. So the Volstead Act is passed in 1819, then the 18th Amendment is passed. Actually, it's passed on January 16th, 1819, but it doesn't go in effect until January of 1920, which is the 18th Amendment that criminalizes alcohol. Now, down here on the prison industry, you'll see that we had 70,000 people in prison in 1920. By 1933, we had 210,000 people in prison. So that's 3 times the rate, 3 times bigger. Now, here's where things really get screwy. We have a 4th Amendment right to be secure in our person, houses, papers, and effects against unreasonable searches and seizures. Well, that would have been fine. But then in 1925, in Carroll versus United States, in the 1925 case of Carroll versus United States, they created what's called the Carroll Doctrine, which would include the automobile exclusionary rule, that you can no longer be secure in your person, houses, papers, and effects, because Carroll versus United States said that they could search a car without a warrant because of the risk of the car being able to roll away. And this is the first major intrusion into our 4th Amendment right. It's Carroll versus United States, right here. Now, Carroll did a lot more than create the automobile exclusionary rule. It also created what's called the exigent circumstances clause. There are 3 specific things that create exigent circumstances. Number 1, if there's going to be a loss of life, police can skip all warrants, skip your rights, and just intervene. Number 2, if the police need to seize contraband, then they can skip your rights and they can violate your 4th Amendment of an unreasonable search and seizure and just go in and seize the contraband, because at this time in 1925, J. Edgar Hoover had become the head of the FBI in 1924, and J. Edgar Hoover and the FBI began to poison bottles of alcohol with cyanide. This is a fact. So now, because it became an exigent circumstance, there could be a loss of life. They must seize the contraband. Number 1, loss of life. Number 2, they have to seize contraband. And number 3, the Carrolls right here, was it George Carroll? I can't remember his first name, but he ran from the police. They passed Carroll, and then when they passed him, they said, "Oh, we got to get this guy." So then, in the Carroll Doctrine, when they pulled him over and they searched his car and they found the alcohol, it went all the way to the Supreme Court because it was an unconstitutional search. Well, then the Supreme Court created that if the police are in hot pursuit of you, well, then they can circumvent your Fourth Amendment right and simply search your car. Now, the exigent circumstances clause and the Carroll doctrine is still applicable today, even though alcohol has been decriminalized and there's distributors. Alcohol is one of the biggest businesses in the world, and we just lost a ton of business, as you know, from Canada, because what happened was, I'm not going to get into that. I'm going to stay really clear on I'm going to stay out of the politics of things, but I want you guys to understand what the Carroll doctrine does. It's created for prohibition. They can unreasonably search you. They can go warrantlessly search your car based 100% on the Carroll doctrine. Carroll doctrine is still in apply today. 1925, 2025, we're still living under prohibition laws. Now, Carroll versus United States is going to be extended. Let me see what you guys can see. In the 1931 case of Husty versus United States. Got it. Are we here right here? Can we see? Okay, there it is. Now, in Husty versus United States, this happened in 1929, of course, during Prohibition. Federal agents had been watching a suspected bootlegging operation, and they saw a guy named Charles Husty and others loading what appeared to be illegal liquor into automobiles from a garage. The agents approached without a warrant and arrested Husty and his associates for illegal alcohol. Remember, this is a Prohibition case. Husty was charged with conspiracy to violate the National Prohibition Act. He argued that the warrantless search of the garage violated his Fourth Amendment right, as garages has the same protections of homes. Now, what has happened here? What has happened here in Husty is we have gone from the automobile exclusionary rule in Carroll versus United States, and now we're going into people's garages and violating the Fourth Amendment based on what? That they have to get the alcohol that J. Edgar Hoover and the FBI is poisoning. Any J6ers out there know what I'm talking about? The FBI has been a corrupt organization since the very beginning. Are there some good agents in the FBI? I'm sure that there are. There's some good people in jails. There's some good people who work in prisons. But what happened, though? Fourth Amendment violated in Carroll versus United States, and they can search your car without a warrant. And now in Husty, they're going into people's garages. Husty makes it so that they can go into your garage, which is absolutely unbelievable. It's unconstitutional, but it's still going on to this day. Still going on to this day. It's going to be expanded even further. Brinegar versus United States, 1949. Let me see what you guys can see. Brinegar versus United States, right here, happened in 1947. Virgil Brinegar was a known bootlegger. Remember, all these things I'm talking about today are based on prohibition. Our country was completely disheveled because of prohibition laws. We've lost our Fourth Amendment because of prohibition laws. Now, in 1947, Virgil Brinegar, he's a bootlegger, and he's working out of Oklahoma, on the Oklahoma-Arkansas border during the post-prohibition era, where still a lot of states had dry laws. Federal agents were patrolling Highway 59, and they spotted Brinegar driving his car. The agents recognized both Brinegar from his car from a previous encounter. They had arrested him about 5 months earlier for illegally transporting alcohol. And they'd seen him loading cases of alcohol into his car about 2 weeks earlier before the incident. So based on past knowledge and seeing his car riding heavily, is what they said, that his car was weighted down, they searched the car and found 12 cases of illegal alcohol. Brinegar was arrested and charged with illegally transporting alcohol in violation of federal law. Now, here's the crazy part. The way that it works. Legal scholars are going to argue that this weakened the Fourth Amendment by creating a subjective standard that police can use what they know as the facts of their mind. Literally, the holding says that a man of reasonable caution who has probable cause to believe that you have broken the law is what probable cause is. Brinegar versus United States creates the probable cause standard that we live by today. And it's not much of a standard considering that anybody can just say that I'm sorry, I'm reading a couple of comments. So what this did is this created the totality of circumstances. Police could combine multiple weak factors to justify searches even when no single factor would be sufficient. It legalized profiling and pattern-based policing. Police could target individuals based on past behavior and reputation rather than the current evidence. It shifted the burden of proof. Instead of requiring clear evidence before acting, police only needed reasonable brief, which is highly subjective. It expanded warrantless searches. It made it easier for police to justify searches without getting judicial clearance first in the form of a warrant. And Brinegar is the case that created the pretext for pretextual stops. So once again, now we've lost our Fourth Amendment 100% because of Prohibition. Let me see what you guys can see here. There we go, great. Which is going to lead us to Rabinowitz. Rabinowitz is where the federal government completely blows away our Fourth Amendment in entirety. I'm sorry, I can't be on camera at the same time. It's really frustrating. Okay, so now right here in Rabinowitz, this happened in 1948, and Albert Rabinowitz ran a stamp business in New York. Now, Rabinowitz was suspected of selling fake stamps to collectors. Federal agents had been investigating him and obtained a warrant charging him with selling altered stamps in violation of postal laws. On February 16th, 1948, the agents went to Rabinowitz's one-room office to arrest him. After arresting Rabinowitz, they found 573 forged stamps in his desks. The stamps were evidentiary and they were forged, and so they had been altered to change the dates and the characterizations. And Rabinowitz argued that the warrantless search of his office violated his Fourth Amendment right. But the thing is the court is then going to uphold a warrantless search. And what it does, Rabinowitz specifically, what it does is it extends the search incident to arrest to the entire business. Back in 1950, if they arrested you, they could search your whole house, your whole office. This eliminated any kind of reasonable scope limitations. It no longer had to be limited of areas where the suspect could reach. This weakened your privacy protections. It created an all or nothing rule. If police could search, then they could comprehensively search everything outside of the scope of why they went to your house to begin with. This overruled protective precedents, specifically overturned Trupiano versus United States. Trupiano versus United States is here, which had required search warrants when you had the time to practically obtain a search warrant. Rabinowitz knocked that straight on its butt. This shifted the constitutional interpretation towards police convenience, prioritized cops' efficiency over individual privacy, and this set the precedence for expeditions where they would just go to your business and just search through all your files, whether you wanted them to or not, and you had absolutely no way at all to be able to fight back against it. And it completely decimated freedom in the United States, where if the cops could go to your house, all they had to do was go to your house and search. Now, Rabinowitz is going to get capped a little bit with the 1961 case of Mapp versus Ohio. I'm going to get one of those things. I'm going to get one of these things on the back of my phone. Let me see what you guys can see. There it is. So in 1961 in Mapp versus Ohio, this is where they go to Dolores Mapp's house in Cleveland, Ohio in 1961. And the case doesn't go to the Supreme Court till 63. And what happens is they go to Dolores Mapp's house, they say they have a warrant, but they don't. And then they go in and search her house. It goes to the Supreme Court all the way up, and then the Supreme Court holds that it's fruit of the poisonous tree doctrine. Because the police didn't have a warrant to search her house, then all of the evidence that they found was fruit of the poisonous tree, and it had to be excluded from the exclusionary rule from 1914 Weeks, which is extended to fruit of the poisonous tree doctrine from the 1920 case of Silverthorne Lumber Company. So this is the very first beginning where we start to get our Fourth Amendment that's going to be incorporated into our rights. This is the case that creates that actually, well, the 1925 case of Gitlow versus New York begins the incorporation doctrine from the 14th Amendment. But then in Mapp versus Ohio, the incorporation doctrine, what it does is it now incorporates your Fourth Amendment into all of the states. So remember, now this is important because the dichotomy here that you're going to see between Kerr versus California and Mapp versus Ohio is really fundamentally how the Supreme Court then begins to kowtow to police, because police are very unhappy that they've created that you have to have a warrant and that's been incorporated to all the states. So the cops hate the Warren Court. They hate Earl Warren. And Earl Warren, who had been a Freemason for 5 years, president of the Freemasons, he had been governor of California. Earl Warren had won every single thing that he had ever gone out for. So now Mapp versus Ohio, where they have to get a warrant, Kerr versus California is going to turn that warrant requirement upside down. Now, Kerr versus California happens in 1960 in LA when George Kerr is suspected of selling Mary Jane. Federal narcotics had been watching him, and he made what appeared to be a drug sale to a guy named Roland Murphy. Federal agents arrested Murphy and found Mary Jane on him from George Kerr. They used a pass key from the building manager to enter into Kerr's apartment. And here's the whole crux of Kerr, that they entered into his apartment quietly. Remember, you need a warrant. Right here, Mapp versus Ohio, 1961, they said you have to have a warrant. Well, in 1963, they entered his place without a warrant and got the key from the building manager, and George and Diane Kerr's apartment was searched, and they found some Mary Jane. The Kerrs argued that the sneak and peek philosophy violated their Fourth Amendment right because police didn't knock and announce themselves. And so you're going to get what's called the knock and announce rule created from Kerr versus California. Justice Tom Clark is going to write the majority decision establishing federal standards. So now here's the whole thing about knock and announce. You have to get a warrant in Mapp versus Ohio. But then with the knock and announce rule, police could now enter homes without announcing themselves if they claimed evidence could be destroyed. This created the exigent circumstances exceptions that is extended from Carroll versus United States. This gave broad authority to bypass the warrant. But just right here in 61, you had to have a warrant. But then in 1963, they say, oh, you don't need a warrant if you knock and announce. This expanded the idea of a reasonable search doctrine, made it easier for police to be able to justify warrantless home entries. This reduced the sanctuary, the castle doctrine. Homes lost some of their special constitutional status against police intrusion. This created subjective police judgment standards that they need to go in and sneak and peek, so they're just going to knock and announce, and they're going to skip the entire warrant process. This encourages the police to use stealth operations. It legitimized surprise raids and covert entries that terrorized innocent people. This set the precedent for the war on drugs, established legal foundations for aggressive narcotic enforcement methods. And remember, back here, this is the narcotics. They're talking about Mary Jane. They're not talking about meth. They're not talking about ice. They're not talking about flocka. They're talking about Mary Jane. It's so absolutely unbelievable. You just, unless you understand it like you understand it, you don't understand. Give me 1 second here. This is what I was needing. Okie dokie. Now I can see you guys and I can talk to you guys at the exact same time. So we're going to continue down the line. There are so many cases here that I'm going to cover that I've made a really comprehensive list because I want to make sure that everybody here can truly understand the next steps. The very next steps are Terry versus Ohio. Now, Terry versus Ohio is the most fundamentally constitutional crushing case that may have ever come down the pipe besides the Dred Scott ruling that cast us into a massive civil war, and estimations between 600,000 and 1.1 million people are killed during that Civil War. And the Civil War from 1861 to 1865, it's not fought like wars are today where you're far away using drones and machine guns. No, the Civil War was fought with a musket where you got shot. Often you didn't die and you'd have to go hand-to-hand combat with a knife and a hatchet. And this was the common tactics for war during the Civil War. But now we're going to slide down the way a little bit here, and we're going to go to Terry versus Ohio. Forgive me, there's one of me and I have 3 pieces, and I have to keep pretty extensive notes here because there's so many cases to cover. Now, this case happens in 1963 when Detective Martin McFadden sees John Terry milling around downtown Cleveland. Now, if you don't know, downtown Cleveland in 1963 is like New York City today. Terry versus Ohio happens in 1963. Remember, black people are not freed in America until the 1968 case of Green versus New Kent School Board. Then America gets freed. So let me just explain it. And let me adjust this a little bit for you guys. There you go. Let me see what you guys can see. So Brown versus Board of Education is supposed to desegregate America. But the truth is that America doesn't get desegregated until Green versus New Kent County School Board. Then America begins to desegregate. That's what happens. There's no desegregation in America until the 1968 case of Green versus the New Kent County School Board. At that point, Hugo Black, Supreme Court Justice, who was a lifetime member of the KKK, he then says that you guys have to desegregate. You have to desegregate now. So when John Terry is milling around downtown Cleveland in 1963, he's not supposed to be down there. You still have black codes very much being enforced. Police are enforcing desegregation, completely and utterly enforcing desegregation. It is a tragedy. It is a crime. It is disgusting. Let me see if I can. Okay, you guys double tap on that screen, hit the like button for me. Let's get a few more likes in here. Let's get a few more people. Okay, so now I'm gonna keep on going down the line. So Martin McFadden, he sees John Terry milling around outside of a diamond store, and he says, you know what? I don't like how he looks. This is in the court transcripts of Terry versus Ohio. Now, let me explain very clear what Terry versus Ohio does. It does 4 things extraordinarily well. Terry versus Ohio creates 4 prongs. Number 1, it puts officer safety over all of your rights. You don't have any rights because of Terry versus Ohio. Because how many times have you been out and you've heard a cop say, oh, I would love to be able to do that, but I can't because of officer safety? That's the first component of Terry versus Ohio, that officer safety trumps your constitutional rights, that your rights can be circumvented in the name of officer safety. Number 2, it creates the reasonable articulable suspicion standard versus probable cause supported by oath or affirmation of the 4th Amendment. Number 3, it creates stop and frisk. If you live in New York, you know exactly what I'm talking about. Stop and frisk with the back of your hand. They're supposed to be able to pat down the outside of your chest where you could have a firearm or along the front of your trousers. That has now turned into a POW style of arrest. And number 4, it creates the detainment part of Terry versus Ohio, where cops can detain you in torture cuffs, put you in the back of a caged car, even take you down to the jail. And if they don't charge you, you haven't been arrested, you've only been detained. Now, I want you to focus really hard on 2 different things: officer safety and reasonable articulable suspicion. Because reasonable articulable suspicion is going to completely and utterly decimate freedom in the cases moving forward. How far is it going to go? It's going to go to body cavity searches. It's going to go to vaginal searches where they can open you up based only on reasonable articulable suspicion. They can put you in torture cuffs and hurt you based only on reasonable articulable suspicion. But I want to stay as chronologically accurate as I possibly can because there's a lot to cover. And now we're going to get into Williams versus Adams, the 1972 case, which should be, it wasn't on the board earlier and I had to add it. Frazier versus Cupp, we're going to get into that one as well. It's here. The 1970, do you know how people always say, oh man, you're going hands on? You hear this all the time where people will say, man, this cop just ran up to me and he went hands on with me. And you're so confused. You're like, how in the world can cops go hands on with me because somebody called the police on me? Have you guys ever experienced that before? Have you ever seen where the cops decide they can go hands on with you? Well, hands on with you is created in the 1972 case of Adams versus Williams. And this happened at like 2 o'clock in the morning in Bridgeport, Connecticut. A sergeant named John Conley was alone on patrol. And you always have this term, a high crime area. And Williams versus Adams is really going to fundamentally entrench an idea that there is a high crime area nonsense. So he gets a phone call that Adams is carrying narcotics and that he's got a firearm. So the informant is named Robert Williams. He pointed to a car parked nearby and said the person, Robert Adams, was carrying chemicals and a pistol. So Sergeant Conley approaches the car and he taps on the window. And when Adams rolls down the window, Conley asked him to get out of the car. When Adams refused and instead rolled up the window, Conley reached into the car and removed a .38 caliber from Adams' waistband where the informant said it would be. Conley then arrested Adams for unlawful possession of a pistol. A full search after the arrest revealed that he had heroin on him. Now, here's the thing. When Adams appeals to the Connecticut State Court, he wins. And then the prosecution then appeals to the Connecticut Supreme Court, and Adams loses. And then Adams appeals to the U.S. Supreme Court, and that's where he loses. And this is where Justice William Rehnquist, but William Rehnquist is not Chief Justice yet. He's only an Associate Justice at this time. But William Rehnquist is I'm going to get into the Supreme Court justices later. But what Williams versus Adams actually did is this significantly expanded police powers and weakened individual rights. This expands Terry versus Ohio stop and frisk based only on an informant's tip. This lowered the reliability of informants. They didn't require police to verify informants' credibility or establish their track record. If someone calls on you because of Adams versus Williams, the cops can run up and grab you and search you. So now when you hear people say, oh, he went hands-on with me right away, it goes back to Williams versus Adams. This also created the armed and dangerous presumption. If police suspect someone of having a weapon, they can automatically frisk you using Terry versus Ohio. The extension of Terry is Adams versus Williams. This created a reliance on unverifiable information. Police no longer needed, at all whatsoever, a verifiable source. And this weakens the privacy in vehicles. This expands Terry stops and to your car, where the cop can Terry stop you in the car. And this legitimizes fishing expeditions. Adams versus Williams does, where they can say, hey, I got a call. And the confidential informant doesn't even have to be revealed. The cops can keep that completely a secret. So this created incentivizations for false tips where people could call on you and I say, hey, I think Letzo TVO has chemicals in his car, or he's got a firearm. Now when I call the cops on you, they're going to go to Letzo TVO's house. They're going to grab him. If he's outside of his house, they're going to reach into his car. It's absolutely morbid. It is twisted. It is sick. And so 72, this is a big case, but it's not really quite as big as what the 1973 case of United States versus Robinson does. And this case happens in 1968 in Washington, D.C., when Willie Robinson is driving on a revoked license. And Officer Jinks knows Robinson personally and was aware that his driver's license has been revoked. This case right here. And so after stopping Robinson, he places him under arrest for misdemeanor offense of driving on a revoked license. And this is the 1973 case of U.S. versus Robinson, a crime that's punishable by up to a year in jail. Could you imagine that you go to jail for a year for driving without a license? The idea that it just drives me absolutely crazy. The idea that we're going to put people in jail for driving on a suspended license or a revoked license, to me, is probably the most morbid aspect of our government and the penal code that's been created, and we absolutely have got to change it. It is so unbelievable. It must be changed. But let me tell you what Robinson actually does. So Robinson, what it does, I'm sorry, there's so many cases, so just try to cut this out in your mind here. United States versus Robinson, police can now conduct complete full body searches for any arrest, even minor traffic violations. This limits the proportionality requirement Searches no longer had to match the seriousness of the crime. Searches now are now based on just whether or not they're going to arrest you. So the cop can just say you're under arrest and search you. This expanded container search powers. Police can open up and examine any container found during incident to arrest, regardless of the size or likelihood of the container containing weapons. They could just search it. This created pretextual arrest incentives. Police can arrest people for minor offenses specifically to comprehensively search them. This weakened your privacy and personal effects. Items like cigarette packs, wallets, or personal containers, it wipes away your constitutional protections. This established a bright line rule favoring police, removed judicial discretion to evaluate reasonableness of individual searches, because if you get arrested, well, then the cops can just go ahead and search everything that you are, your car and everything around you, because remember, we're still living on the Rabinowitz factor from 1950, that if you get arrested, they can search everything, your house, your office, anything around you, anywhere they believe that there's going to be either contraband or a firearm. Okay, so now we're going to move down the line here. Oh, we're back to Kurt. Let me see where you guys can see here. Let me just take a look at the camera, make sure you guys can see this. Okay, so now we've seen that they have created the automobile exclusionary rule, that they can just search your car because it can roll away, and so they can search your car. Now, in the 1975 case of Brigoni-Ponce versus United States, this happened in 1973 near San Clemente, down by San Diego on the Mexican border. Felix Humberto Brigoni-Ponce is driving north on Interstate 5 when he stopped at the permit border to check to see if he has any illegal immigrants in his car. The Border Patrol agents, and we're taking a look at, here, my finger's in the wrong place. We're taking a look at this case right here. So he appears to be of Mexican descent, Brigoni-Ponce does, and the agents had no warrant, no probable cause, no reasonable suspicion of any specific criminal activity. And when they stopped the car and questioned the occupants, they discovered the two passengers are undocumented Mexican nationals who had entered the United States illegally. Brigoni-Ponce is then arrested and charged with knowingly transporting illegal aliens in violation of federal immigration law. He argues that the stop violates his Fourth Amendment right because it's based solely on the appearance of his appearance that he's Mexican in descent. Now, when he goes to court, when he goes to federal district court, he wins. Brigoni-Ponce is convicted and he loses the case. But then when he goes to the Ninth Circuit Court of Appeals, the Mexican guy, he wins and conviction's overturned. And they say, you can't just stop someone without any reasonable articulable suspicion. We created a Terry versus Ohio standard where you have to have reasonable articulable suspicion. The Ninth Circuit overturns his case and Brigoni-Ponce is freed from jail. Now the government appeals to the U.S. Supreme Court, and guess what? The U.S. Supreme Court overturns it. Justice Lewis Powell wrote the majority decision that immigration stop checkpoints are perfectly constitutional. Now, legal scholars are going to argue that this case works against the people. This legalized immigration checkpoints, right here, Brigoni-Ponce, created border exceptions to the Fourth Amendment. People near international borders have reduced constitutional protections. And that's not just the Mexican national, that's you. That's every single person watching this. You lost your constitutional rights by the border. Put a 1 in the chat if you've driven by a border and they've wanted to search your car and they've asked you questions and they're telling you that you have to answer the questions. It's so unbelievable. This legitimized ethnic profiling, where they can profile you just based on the color of your skin. Is that what's happening today? This created a two-tier constitutional system. Americans near the border and Americans away from the border. This encouraged pretextual stop of immigrants. This disproportionately affected Latinos. This set a precedence for suspicionless stops if you're just near a border. And that's what it does. So a lot of people, I did this last night and I wasn't 100%. So let me show you something. A lot of people will say that you don't have any constitutional rights in this country if you are an illegal immigrant. So I went over Brigoni-Ponce last night in my studio here. I spent maybe an hour on it. And so now I have some questions that I'm going to ask to AI here. And for the people who say that illegal immigrants don't have constitutional rights, as you can see, this is live. I can't set this up. This isn't fake. This is what I'm going to show you something, and this is going to blow you away. What's up, Playboy? So I'm live right now, and I'm talking to my audience on YouTube. I'm talking about the 1975 case of Burgoni Ponce versus United States. Now, Burgoni Ponce was an illegal immigrant, wasn't he?
Hey there. Yep, absolutely. So Burgoni Ponce was indeed an undocumented immigrant, and the case revolved around the Border Patrol stopping his vehicle to check for unauthorized immigrants, purely based on apparent ethnicity near the border. The Supreme Court ended up ruling that this kind of stop wasn't justified by just that factor alone. So you've got it right. He was undocumented, and that case is a pretty significant piece of Fourth Amendment and equal protection jurisprudence.
Well, then Burgoni Ponce was a Mexican national and an illegal immigrant, but yet when he was convicted because they stopped him without any reasonable articulable suspicion, he appealed his case to the Ninth Circuit, and the Ninth Circuit overturned his case. Does that mean that Burgoni Ponce had constitutional rights because he's in American jurisdiction?
Yeah, you've got it exactly right. Essentially, yes, the fact that Burgoni Ponce was in the United States meant he did have constitutional rights. The courts, including the Ninth Circuit and ultimately the Supreme Court, have long held that once someone is on U.S. soil, entitled to certain constitutional protections, like the Fourth Amendment's protection against unreasonable searches and seizures, even if they're not citizens. So, in short, yeah, Burgoni Ponce's successful appeal does show that he had constitutional rights because he was under American jurisdiction.
And so the Supreme Court wouldn't hear a case based on constitutional rights if every single person on American soil didn't have the same protections as every other person on American soil. Is that correct? Isn't that a century-old precedent that if you're in, more than a century-old precedent, that if you're in these United States of America or on American territory, that you have constitutional rights regardless of your immigration status?
Yeah, that's absolutely correct. It's a well-established principle that if you're on U.S. soil or in a U.S. territory, you're protected by the Constitution in a fundamental sense, regardless of your citizenship or immigration.
And that would include that you get due process of law if you're going to be put in a prison, correct?
Absolutely, you're spot on. That definitely includes the right to due process if someone is going to be detained or imprisoned. So whether someone's a citizen or not, if they're on American soil, may have the right to fair legal procedures before being deprived of liberty.
Now, wait a minute. This is live, right? This isn't some recorded thing that I had you say. You're not just saying this out loud because I have an agenda to be against due process, right?
Nope, this is totally live. I'm right here responding to you in real time. There's no pre-recording or script, just answering your questions as they come. So you're good.
Boom. So this is the problem that I have with so many people around the country. Let me just clarify this a little further. So this is going to be based on the 14th Amendment, correct? That you have constitutional rights on American soil. This is based completely on the 14th Amendment. Not completely, but almost completely, right?
Yeah, you've got it pretty much right. The 14th Amendment is definitely a huge part of that foundation. It's the amendment that really lays out equal protection and due process for anyone under U.S. jurisdiction. So while it's not the only amendment that provides rights, it's definitely cornerstone of why everyone on American soil has those constitutional protections.
So, when you hear people now, and you guys can just do the math on this yourself, when you hear people now saying that you don't have constitutional rights if you're an illegal immigrant, there's almost 200 years of jurisprudence, of stare decisis, of case precedent, that if you're on the soil of these United States or the territories, U.S. Virgin Islands, Guam, that you have constitutional protections. And either you are for the Constitution and you're for our rights, or you're not. But you have to do your own research here. There's 200 years of case precedent here, including the 1975 case of Burgoni Ponce that says that if you're here, you have constitutional protections. I'm not for illegal immigration. I'm not a big supporter of illegal immigration. But the thing is that we have the right to have due process if you're in this country. And if you don't, sorry, go ahead and do your own research, B. I saw your comment, but listen, you've seen me do hundreds of audits where I tell the cops I'm a constitutional law scholar. I built this wall. I've been studying this stuff in depth for the past year at crazy levels, even understanding that some of the things I said in the past were wrong. And I'm going to correct those things now over the next couple weeks here as I teach on this wall primarily. Do me a favor, hit the like button. If you're learning anything, hit the subscribe button. And we're going to keep going down the list here. Because after Burgoni Ponce, remember, everything has been decimated based on prohibition. They illegally searched Burgoni Ponce based 100% on the idea that you can illegally search a car with the automobile exclusionary rule. Do you see? That you can illegally search a car based on the automobile exclusionary rule. Now, Burgoni Ponce is just one kink in the armor of ending our constitutional rights. Because of the 1976 case of South Dakota versus Opperman, this happens obviously in South Dakota. Opperman's parked his car illegally on a main street in downtown Vermillion. When police found the car, they issue him a ticket, and they noticed that the car has been ticketed for other parking violations. Opperman's car had gotten parking tickets. So before towing the car, Officer Frazier conducted what police called a standard inventory search. That standard inventory search is deemed to be unconstitutional because he notices that the glove compartment's also unlocked. When he opens the glove compartment to inventory of contents, he finds a small plastic baggie of marijuana. Opperman is then charged with possession of marijuana. They search his car for parking tickets because the automobile exclusionary rule. That's what happens. So now Opperman is going to argue that his Fourth Amendment right was violated because the police had no warrant and no probable cause to search his glove box, even though they found drugs inside. So when South Dakota versus Opperman goes to the state court, the government wins. Opperman appeals to the South Dakota Supreme Court, and his conviction is overturned. And in South Dakota, to this day, you cannot inventory search a car. It's illegal in South Dakota because the South Dakota State Supreme Court has said that inventory searches are unconstitutional. But the pesky prosecutor in South Dakota, he appeals to the U.S. Supreme Court, and the U.S. Supreme Court overturns it and says that Opperman is guilty and upholds his conviction for him to be in jail. It's absolutely preposterous. But let me give you the breakdown of what it does. South Dakota versus Opperman, police can now search entire vehicles without warrants or probable cause, claiming administrative purposes. This eliminates the warrant requirement. Cars lose all Fourth Amendment protection once it's towed because they have to inventory your car because of South Dakota versus Opperman. This allows fishing expeditions. Police can search for evidence while claiming they're just inventorying your car. This expands the container search authority. Glove compartments, trunks, bags, anything in your car can be opened without judicial approval because they're only inventorying your car. This creates incentives for pretextual impound. Police will tow your car for your registration being out, your blinker not working, and then when they tow your car, now they have a right to inventory your car. This established the standardized procedure loophole. The standardized procedure loophole, I'm not just making that up, that's an actual quote from the government. Standardized procedure loophole. As long as police follow written policies, they can bypass your Fourth Amendment and inventory your car. Now, of course, this is going to adversely affect poor people, black people, Mexican people, people who don't have any money, all because of South Dakota versus Opperman. It's unbelievably unconstitutional, but it's going to get even worse. It's going to get even worse because now we're going to jump up here to Pennsylvania versus Mims. And I want to really explain Pennsylvania versus Mims because I've been wrong about it in the past. I'm admitting right now I've been incorrect about Pennsylvania versus Mims in some of my analysis. And I want you guys to truly understand Pennsylvania versus Mims in a real world, deep way. So I'm going to explain the case background, and then I'm going to explain how we get where you have to get out of the car. In 1976, two cops, Harry Beard and Thomas Cuffman, are on patrol, and they observe Harry Mims. Harry Mims is driving a car with expired license plates. Isn't it always the same? Expired license plate, your license plate light doesn't work. After they pull over Mims, they approach the driver's side of the car and ask Mims to step out of the vehicle, which is a violation of your Fourth Amendment right to be secure in your person, houses, papers, and effects. But as he exits the vehicle, Officer Baird notices a large bulge under Mims' sport jacket, suspecting it might be a weapon. The officer frisked Mims and discovered a .38 caliber revolver tucked into his waistband. Mims did not have a permit. And that's the other thing. You need a permit to carry a gun, which is, we're going to go into Second Amendment law. This is all Fourth Amendment law today. So they search his car and they find an unregistered illegal gun. So he's charged with carrying a concealed deadly weapon without a license and unlawful possession of a firearms, which again goes back to the 1968 Omnibus Crime Bill, which we haven't gone into yet, but I will in the future. Mims argues that ordering him out of the car turned a simple traffic stop into an unreasonable seizure under the Fourth Amendment. So this is the crazy part about the Mims case. He goes to state court and he loses. His conviction is upheld. He goes to jail. He's put in prison. Then he appeals to the Pennsylvania Supreme Court, and his conviction, Mims' conviction, is overturned. And then, of course, the pesky prosecutors in Pennsylvania, they then apply for certiorari to the U.S. Supreme Court, and the U.S. Supreme Court overturns the Pennsylvania State Supreme Court holding and says that, and, oh man, and says that, there we go. We got you guys back? We got you guys back? Hopefully I got you guys back here. Are we back? I want to keep going on this, and I don't think this is going to be the best format. I've got to get a little device here, and I've got to just record this on the static. I want to keep going on this, but unfortunately, this little area of my studio, for some reason, there's an internet blackout right here, so my internet. I would love to keep going on this live stream. Can you guys hear me okay now? So I want to keep going on this live stream, but unfortunately, I feel like this little corner of my studio is like an internet blackout, and I can't really teach you guys like I want to teach you. So I'm gonna cut this live. I'm just gonna go over some cop videos. This is the whole problem with this wall that I've been dealing with, is I can't really teach on this wall without all kinds of technical problems. I'm having a hell of a time, and it's really frustrating because I have a lot of knowledge and information that I want to share with you guys, because obviously if I built this wall, I've been studying this case law for years, and the past year I've done such an intensive study, I found my own mistakes. And so I just want to make sure that yeah, and so let me show you guys something else here. No, it's just gonna cause me all kinds of problems. I know it, smoking guns. I know it. What I really need is an assistant in here to use my slider so that we can slide up and down this wall. I will get an internet. I know all the words are jumbled. All right, listen, I'm gonna be back on live in about maybe 5 or 6 minutes. I'm gonna set up at my desk where I have great internet connection. Thanks for watching. I'm sorry I can't keep going on this. I'll be back in like maybe 10 minutes. Thanks for coming. I'll see you guys in the next one. Later, Gators.